regulations weren't updated enough to allow that, so we gave them a variance to do that. And so, as I said, when I looked at it as a citizen, that seemed like a good thought. And as a lawyer, the legal effect is that if we do it, nobody appeals, in 30 days, we're right. That's it. So that's also something to think about. If you are thinking of how you can advance the agenda sometimes. So that's kind of how I approach this as a member of a board or commission, certainly not as a town attorney. Now, as I said, and if I could just start clicking through here. This is my disclaimer. The purpose of this is educational, that this is not a substitute for proper legal advice. We want to help you understand the rules and the issues that you may face so you can do your job better. But the application of general rules to specific situations requires legal consultation. And what I'm going to explain tonight, there'll be a temptation, because I did this about 10 years ago, and people took this handout and then would come to town meetings and quote from the handout about what I had said and try to apply it to specific situations. And so what I'm going to tell you is that that's really difficult to do. Most of this is general information. That's the point of this. This is educational. And if you need to ask a specific legal question, then you need to ask a lawyer and specifically ask the question with the specific circumstances and facts so you can get a correct answer. So this really is not a substitute for legal advice. I'm going to start with freedom of information. And freedom of information is a good place to start because the freedom of information rules are the genesis of a lot of the rules that you have, your council rules, a lot of the procedural rules. Those rules evolve because freedom of information has requirements as to how you conduct meetings, the records, et cetera. And so in order to meet statutory requirements, most towns have adopted rules that meet those requirements, but the real core of those is the statute, which you have to follow. It's a state statute, so you have to follow it. I always say that freedom of information is good. I 100% support freedom of information, transparency in government, and access to records. However, sometimes, you can have too much of a good thing. And I have found as a lawyer that many times freedom of information requests are used as more legal tools than they are a legitimate search for information. And so as a lawyer, that's no problem. We defend those and we charge the town and, and that's the way the system works. But I would encourage everyone to follow the freedom of information rules as scrupulously as you can to avoid any of these controversies. And if you do that, and you do that in good faith, you're going to avoid most of the controversies. And I'm going to go over the general rules here. So freedom of information, it covers two broad areas, the public records and the conduct of meetings. And it's subject to very narrow exceptions, which are strictly construed, which means that the court, when they look at them, they're going to look at it as narrowly as possible. Our Freedom of Information Commission is relatively famous in this country as really being one of the first commissions to really start freedom of information with, I think, Mitch Perlman at the very beginning. And they really take it seriously, and they run a very professional operation there. They have their own, basically, system there. And so we start out with the meetings of public agencies. That is a meeting. That's going to be subject to freedom of information, okay? And a public agency can also include a single person that's engaging in a governmental function like a town manager. And it doesn't include like vendors. So if you're an IT vendor and you're just providing services, you're not going to be a public agency. Your information is not going to be subject to the Freedom of Information Act. All right. And the records of public agencies. And the definition is very broad, as you can see from the very beginning. It's any recorded data or information relating to the conduct of the public's business. that is developed, prepared, used, received, maintained, or retained by a public agency, which is basically pretty much anything that you're looking at and considering when you're considering applications and you're having your meetings. There's very limited exceptions to this: preliminary drafts, personal medical files, attorney-client privileged documents. However, the exclusive remedy for violations of the Freedom of Information Act is to bring an action in front of the Freedom of Information Commission. There's no private cause of action. So you can't use the statute to say, well, we're going to sue you for damages based on that. The one thing I would say is that one of the things the Freedom of Information Commission can do is it can invalidate the action of a board or commissioner of a town council if it fails to follow the Freedom of Information rules. And I call that the atomic bomb, because if you have taken official action and you have an FOI complaint that takes a year or two to unwind its way through the system, and at times those can go to the Supreme Court. And I'll give you an example of a case where there was a police chief that was discharged from employment, and there was an emergency meeting that was used, and they didn't follow the FOI procedures properly. And 2 years later, when the Supreme Court ruled that they should have, and he never should have lost his job, the town had to pay him $400,000 or $500,000 in back wages because they invalidated the action. And I'm going to talk a little bit how they could have avoided that. But the point is that it is serious, and you have to be careful, and that is the real, in my view, the most serious consequence is if they invalidate the action that the board or commission or council took. Because it'll take years to really totally litigate it, and by the time you find out, there's potential to have a lot of damages. And then we go to the question of what are meetings. Anytime you have a quorum of a public agency to do business, basically, that's a meeting. So if you got a whole bunch of members of your planning and zoning or I'm not trying to pick on anybody, these are just examples, and they're doing emails to each other, and the people that are in the email chain constitute a quorum, then you're having a meeting, and those are all minutes. I mean, they're all subject to FOI disclosure. So you need to be careful, even on a conference call, because once you have a meeting, you need it to have an agenda, and you need it to have minutes, and you got a quorum, and you're not going to have that. You're going to commit an FOI violation. You're going to have to hire me. And I'm probably going to tell you, you shouldn't have done that. And, let's be reasonable about this, and we won't do it again. But hopefully, because we're having this conversation now, it won't happen at all. And I think probably most of you probably have already heard most of that and know better. And then, as I said before, administrative staff meetings in a single-member agency are not meetings. Town manager, fire chief, if they have their staff in, that is not a meeting that's subject to FOIA. They're not going to have minutes or an agenda and tell you, any issues that they're having with regard to how they're running the town. Now, there are statutory exceptions that are not subject to FOIA, and that is if you have a meeting of a personnel search committee for executive level employment candidates, and that means executive level employment candidates, not someone who is not in that position. So you can't use that if they're not an executive level candidate. Chancellor social meetings. So if you all end up being at a restaurant together and it just happened that you all went there for dinner and you happen to have a quorum, that is not a meeting subject to FOIA. Strategy or negotiations with respect to collective bargaining. Caucuses of members of a single political party, even if it is a quorum, and that is allowed specifically under the statute. And then if you're just having communication because you're trying to set up the meeting, that's allowed. So if you're running emails and you got a quorum and it's basically, should we meet Tuesday or Wednesday, start whatever, that's allowed. You're not doing anything substantive that the public should need to know about, other than you got to give them the proper notice so they can make it to the meeting. And if you all decide to attend a town council meeting together or a like meeting so that you have a quorum, but you're not there to conduct business, you're not there for a meeting, that is also not considered to be a meeting. Like tonight, this is not considered to be a meeting under Freedom of Information. We're not here to conduct business, even though we may have a quorum sitting here, I don't know. It doesn't really matter. Now, we've got the types of meetings, and so when I mentioned before that freedom of information is sort of the seed of a lot of the rules, well, here they are. You have regular, special, and you've got emergency, which is on the next page. And these statutory requirements pretty much are followed by your town council rules as to how they're going to do the meeting, the notice, et cetera. So you pretty much, you follow that, and you obviously have to do that. And I'm really not, I'm not really going to spend a lot of time on that. But I am going to say that the one thing that occurred was with COVID, we did have special rules for remote. And the major differences, and it's really hard to find them. You got like an implementer bill and the rest of this stuff. It's really hard to find it. But the major differences have been that you need to give 48 hours notice instead of 24, that you have to put it on the website. It used to be you have to put it on the website if it was a regular meeting. And you have to have a roll call vote, so we know who's voting. And then I also think that there's probably some ADA issues with regard to access when you're doing remote, which I'm not really going to cover, but under the Americans with Disabilities Act, you have to make reasonable accommodations. And so if you're doing remote, you have to make accommodations so people can participate to the extent that they want to. So those are the major things that are different because, and I'm not going to get into an exhaustive thing because I think that we're going to be moving on for most of those regulations is what I really think the state's headed. So, yes, executive sessions. So executive sessions are not open to the public. They're not really considered a meeting under Freedom of Information. And you need to have 2/3 of the members present, have to vote to go into session. And only the people that really need to be there should be there. You shouldn't be inviting anybody that doesn't absolutely need to be in that meeting there. Now, executive sessions can only be called for certain reasons, and that's discuss the appointment, employment, et cetera, of evaluation, health, dismissal of a public officer. And I've listed them right out there. Strategy and negotiations with respect to pending claims and litigation. And discuss matters of security, site selection for lease or sale or purchase of real estate, and any matter which would result in disclosure of exempt public records. So a couple things about that. First of all, the one with regard to the lease, sale, or purchase of real estate, that one, the reason for that is that those types of negotiations, when they become public, affect negotiations and price. And so if you have a town that's negotiating to buy or sell, et cetera, and it becomes public, then you have all of a sudden other bidders, other buyers, et cetera. So because of that, Freedom of Information recognizes that, and that's the policy behind that. The next one, discuss any matter which result in disclosure of exempt public records, is really a very large exception because there's many public records that are exempt from disclosure. So if you talk about those records, then that's exempt from Freedom of Information. And one of the things that very often happens is that draft documents are prepared, and when draft documents are discussed in executive session, they are not subject to Freedom of Information until they become final documents. And that's just one of the many types of documents. There's a lot of potential exceptions to the Freedom of Information Act. Now, in an executive session, you're only allowed to discuss whatever the matter is that's before you. You have to take all your votes, have to be in open session. And your minutes have to include the vote to go into session and the reason for the session, the people who are attending, and then when you come out. So you have to have all those things, even though you're not going to have minutes of the meeting itself, et cetera. But you need to identify it sufficiently so that there's notice of what you're going to talk about generally, all right? And I find that I notice that, and I know that the town, Rocky Hill does too, and a lot of towns have a placeholder executive session spot on their basic agendas. My advice is if you're actually going to have an executive session on something, you should put it in the topic. Don't try to use the placeholder because it could be a problem. It could become an issue, and if you try to use the placeholder, then you need to make very specific representations on the night of the meeting, and you should ask your town attorney if you're going to do that, but you really should not do that because it's not really fair. to have just say executive session. It's always on your agenda, which is not you, but I know another town that actually does this. And it's always on there. So how's the public supposed to know if you're really going to have one or not if you never put it in there? And that's really the point of this. This is not a gotcha game, hopefully, okay? We want to have people come in and understand if something's going to be on. They can participate. That's the point of this and why everybody's volunteering. Because I don't think anybody gets paid, right? So, that's the point of this. The other thing is that the Freedom of Information Act itself does not create confidentiality. So when you go into executive session, there's no duty to disclose. That's what Freedom of Information says. It does not say that that information is confidential. In order for it to be confidential, you need rules like you have and your council rules that say that it is, and you also have ethics rules that say that, so I'm going to cover. But if you don't have those rules, you cannot just rely on executive session, and I've had this in other towns where we've read about things in the current, and we have had ethics complaints filed, and this has been litigated. So by itself, it does not create, it's only part of it. No duty to disclose, fine, that's part of it. But the other part is you have to have some privilege, either because you have a rule that says if we're in executive session, that's confidential, you don't disclose it, or I've had a situation where I've had to tell counselors that the advice I gave you was attorney-client, and while you could waive it, the client can always waive attorney-client, in a situation where the town is the client, you need a vote of your counsel. If any of you individually waive it, you'll be committing a violation. So there are times when these become very important distinctions depending on the topic, because there's at times, and I'm not talking about Rocky Hill at all, but at times there's situations that occur that are hot topics and they become very contested and people get really, they ignore the rules. Like I said, you end up reading people in the current, you have people filing complaints against each other. And I think you can avoid all that by being really clear. This is confidential. You can't disclose it. There'll be consequences. And you guys pretty much have that in your rules. All right, wait a minute. All right, okay. Miscellaneous meeting requirements. I kind of went over this. The agenda should be adequate to identify to the public the business to be transacted. I've gone over when the minutes, et cetera, have to be published and what you need to put in the minutes. You have to reduce everything to writing in 48 hours. And while freedom of information provides the public the right to attend meetings and to have the disclosure of records, it does not give them the right to participate in meetings. So if you have a meeting where you don't have public comment, you don't have public discussion, no one gets to do it, you don't have to let them because of freedom of information. There's no affirmative requirement just because of freedom of information. However, and I'm going to get to this, if you do allow public comment, and then you've got to allow it, and you've got to be fair and even-handed about it. Oh yeah, right, okay, so with regard to other meeting requirements, the members of the public and the media have the right to record or broadcast meetings, but the agency, the council or the agency can establish procedures in advance for that so that it's not disruptive. And if the media does want to do that, I suggest that that's what you do, because you really can, it really can become disruptive, especially if you have a meeting that's, and that has a lot of publicity. If a member of the public creates a disturbance, you can remove them and you can clear the room if you have to. The media is allowed to remain as long as there's not a security risk. But you can clear the room and you can control the meeting. Unfortunately, as the chairman of the Zoning Board of Appeals, I had a very contentious hearing where one of the relatives of the applicant became extremely abusive and loud, and we had to have him removed. And luckily, that meeting took place in our police department community room, so we were right there. It was easy, but this, in my one experience and all the time I was on. But it can happen, and you've got to keep control. You can't let people get out of hand, and I don't, I understand there's not always staff, et cetera, so that's going to be a fine line, typically. I've had instances where I had one particular planning and zoning meeting that I was involved in where I was a lawyer in the hearing, where the town knew it was going to be contentious and they called the state police in. So they had 2 troopers in the back of the room, and it did get contentious. But those are all things, once again, if you ever have those kinds of situations or you think that could be happening, you should let us know. Certainly let Dana know, let Ms. McGee know, and let the town manager know. Because one of the things that happens is with a lot of local boards and commissions, you have liaison issues and, people don't really always communicate and know what's happening. So the chairs really have to kind of take control of that aspect of it if you anticipate problems. And then if you change the location of a meeting, you have to give 30 days in advance notice and post it in the town clerk. If you can't give 30 days, then it's going to become a special meeting and you can't add new business. Okay. So this is just basically says that you have to let people look at your records, okay? And you have to let them promptly inspect the records during regular business hours unless they're exempt. And you can't make your own rules to exempt your records. You have to follow the state statute. So you can't pass an ordinance that says we're exempting these records, we're not going to give these either. You can't do that. And the definition is very broad, as I said before. And the one thing that I would say about this is that if you are using a computer to communicate, and you are using your personal computer to communicate, and this has happened, and there's a question that you're not being straightforward with FOI, and they're looking for records, you could have a forensic audit. They're going to take your hard drive and they're going to check it. So that could actually happen. So what I would say is there's a couple of points with that. First of all, most towns, and I would assume this is true in Rocky Hill, I'm pretty sure, that most elected officials, and I don't know if all the board and commission members, but there's always town emails. So if you're going to use a town email account, you should use the town email accounts. If you're using your personal accounts, you need to somehow create a folder or something. You need to be able to prove that you're separating it. But I would not do business with your personal accounts. I just would not, because you're going to subject yourself to the freedom of information and to potentially having, somebody come to your house and look at your computer, and it's happened. So beware. That's all I'm going to say. Anytime you're using your own personal email, and this is just a general rule for everybody. I think we all know this. Anytime you're going to hit that send button, think twice. Now, there's a lot of exemptions to the disclosure of records. And so what I did was there's a separate handout, because I am not going to go through this thing. This is a lot. So there's a lot of exemptions to disclosure of records. Now, the first set are right in the Freedom of Information Act. There's preliminary drafts. Personnel records, if they're going to be intrusive, generally if they have to do with the performance of an employee, they're going to be disclosed. Employee gets a chance to object. I strongly recommend you give the employee a chance to put their position as to why they shouldn't be disclosed, but they're generally going to be disclosed. And I just have a whole bunch of them in here. I mean, there's all kinds of things that, there's trade secrets, educational records, the addresses for judges and police officers. There's a whole bunch of stuff. So it's pages and pages of it. We got it pretty much footnoted, and I basically sent it to Dana so she could look at it. Since she handles most of the FOI requests, I believe, originally that come into the town. So, if you take notes, though, all right, your personal notes are not a public record. So if you take the notes, they're not a public record. However, if you use them, and you start telling other members that I remember this because I took notes and I got my notes, and you use them, my position always is that anytime you use something that you're using to make a decision or deliberating, you should mark it, make it an exhibit to the record in whatever you're hearing, okay? So I would just say that on the personal notes, yeah, they're personal notes, and you can use them for yourself, and you can use them and think, this is how I'm gonna remember, but I wouldn't tell somebody else, I know better because I have the notes, here, look at them. That would then, it would open you up to then, well, let me see the notes, because I love handwritten notes as a lawyer. I can ask a billion questions about them. So I just say that on that. And then I already talked about the issue with regard to the personnel records. Oh. Okay, mechanics of disclosure. You have to make the request to the, wait a minute, no, I missed one. Hold on a second. Here we go, I'm sorry. The request must be made to the public agency official who has custody or control of the public record. There is no obligation to create records where none exist, except agendas and minutes. Because if you don't have those and they don't exist, you can't create them after the fact. That would be bad. If you don't have them, you don't have them, and you've committed an FOI violation. So those, you know, if they don't exist, that's bad. Otherwise, if they don't exist and they want them, they don't exist. You know, you're not obligated to create anything. And we don't. It doesn't require public agencies to conduct legal research or respond to questions. It requires the agency, the town, to provide documents. That's what it requires. And there's many ways to request those and then get complicated, but at their heart, that's what it requires. You know, you can't ask questions like, why did you decide to vote this way? Or, there's many things that people try to ask many times with these requests that are not appropriate, and that's how we respond to them. Now, this is an area I think that's a little bit murky on the last part. You have 4 days to respond. What that generally means is you got to reply within 4 days. So if somebody makes a relatively complicated request to you, or even a substantial request, you can tell them in 4 days, we got it, we're working on it, and we'll get back to you in X amount of time. But if you have somebody come into the clerk's office and ask for a very specific document under Freedom of Information that can be easily gotten and provided, that's what you should do. Because if you do not, and it was easy to do, and you refuse to do it, that is going to be a violation under the Act. And I've given you an extreme example because that's what happens when the FOI people go to town halls and they do this to find out if you're going to do it. The other thing is asking them why they want something. You cannot do that. You can't ask them, why do you want this? They're entitled to get it, and they're entitled to get it reasonably promptly. And I do understand the absolute mechanics and the burden of this, to do it in the 4 days and to do it. But if it's something simple, that it's easy, you should just do it. You avoid problems. You avoid getting a call from Tom Hennick, who is a great guy down there, who usually calls and says, hey, I got a call, what are you guys gonna do? So we always try to just resolve these things as informally as possible, because they end up becoming legal issues that just it can become very costly. Okay, am I going the wrong way on this? Okay. Then I got the fees with regard to copies, and if you have to have data that's not a copy, whatever the actual cost of making the copy is. And they do allow you to have handheld scanners. So if you want to go in and make the copies yourself with a handheld scanner that's not disruptive, you can do that. You can't use flatbed scanners. Those have been found to be disruptive by the FOI. And if you are anticipating that you're going to have people with handheld scanners, then you probably should pass some kind of a rule or regulation as to when they can use them and how, et cetera. Just so that they don't impede your office, your operations. And so that is basically the end of the Freedom of Information presentation. And I'm going to take a break now, but before we do, I wanted to see if there were any questions with regard to anything that we presented so far. Great. I'd like to take a 5-minute break before we come back. Does that work? Thank you. Yeah, 5 minutes. Okay. All right, well, I'm not going to go anywhere. Set to go?
Want to give them another opportunity to ask questions?
Sure.
Okay. Thank you, folks. I'm going to ask everybody to find their seats again. And one more opportunity for those folks that would like to ask a question on the FOIA section. I did have one or two people walk. Did you get your question answered? Yeah, you're set? You're good? Okay. It might be helpful. You want to ask it publicly?
Sure.
Sorry, I put you on the spot.
Ask me. This will be a surprise.
Hey, Morris. So I was wondering whether or not a Zoom recording would substitute in lieu of written minutes. Thank you.
That's a good question, and I would say no, but I'd have to really take and do research on that. But my initial reaction would be no. In fact, I'm 90% sure the answer is no. So I had a situation in another town where that's what they had. They had a Zoom, and they didn't have the minutes. And I think that the real issue was on accessing the Zoom. That was a real issue. It was almost impossible to do, and it certainly didn't meet ADA requirements. And I don't know that it would substitute for written minutes in any event. But the access issue was a huge issue on minutes. I mean, you need minutes. We're going to file a Zoom thing in the court, because if you file an appeal, which is what this situation was, and you're going to court, you're going to file the Zoom video in the court. The court's going to want a transcript. They're going to want minutes. So I would, without doing specific, as I said, this is general education, so my off-the-cuff answer is that I would not. But certainly having it, you can make minutes pretty easily if you've got it. So any other questions before we go on? Great. I mean, I think freedom of information is something that most folks hear quite a bit about if you have any experience with boards and commissions. And I know that FOI also does presentations, which are very good. So I think hopefully this just reinforced what a lot of you folks already know. Now we're going to talk a little bit about ethics. And so I kind of broke this up a bit. Obviously, you have an ethics sections because you want the public to be confident in the integrity of government. And in Rocky Hill, we define that by maintaining the utmost standards of personal integrity, truthfulness, honesty, and fairness in carrying out public duties. The overriding principle is that public office is not used for personal gain. And so in the ethics code in Rocky Hill, the key phrase is personal gain. Whereas in other, there's other codes and general law that ties into financial gain or benefit, et cetera. But I think that it's all the same meaning. And I've kind of gone through conflict of interest are prohibited. And if you take action that results in personal gain, and a personal gain is if you expect to or derive economic gain as a result of your vote or official action, which is an excess of the gain to be derived by the members of the public in general. So if you pass a tax cut and everybody gets it, you're going to get a personal gain. But everybody's getting it, so it's all right. It's not a conflict. If you pass it, you get a bigger tax cut, that's a conflict. So it's pretty simple what that really means when you look at it that way. And your code doesn't specifically address these situations, but I believe that given the code that you have and the common law as well as the state law, that you would also have a conflict if a close relative or business associate, would be in a position to derive personal gain. And you would have a conflict if a business you had a controlling or substantial ownership interest in were to derive such a personal gain. Once again, just because it's the ABC Corp that you own all of, that doesn't mean it's not you and that you can vote, because ABC Corp's going to benefit, not me. It's a separate entity. That's, the rules don't work that way. The real question is substantial ownership interest. That's kind of a fuzzy line. I mean, if you vote for something and you own, let's say, GM stock, and you vote for something that's going to benefit GM, well, that's not really a personal gain for you. I mean, it's just not. That's not a substantial ownership interest. I mean, you're like many other stockholders. A lot of people don't even know they own that. But if you have a controlling interest or even a substantial, like you own 40% of the stock of a company, then that gets to the point where that is a personal gain, and you have to be careful for that. You shouldn't try, I mean, you guys all know this. You shouldn't try to hide, an interest that you have so that you can vote. You shouldn't vote. Simple as that. And you all know also, and this is just common sense, anytime you do something, you know if you're doing something that you think is questionable. You know. So whenever you think that, don't do it. All right. Okay, now your code requires that any official, that's the typo. Should be any official, officer, or employee of the town has to disclose if you have a financial interest. And you have to disclose it in writing, and you have to recuse yourself. And if you don't recuse yourself, that will be a basis for appeal, according to your own ethics code. So that if you vote on something you should recuse yourself on, your code says it's basis for appeal. I don't know how that would work if you actually got to court, but it would certainly give the appellant a ground to pursue an appeal on that. And I saw a question.
Sure. When you're recusing yourself, you don't have to delineate.
You don't have to say, you shouldn't say. What you should do is, and I'm going to cover that. I'm going to cover that as we go, but when you recuse yourself, what you should do is just excuse yourself. You just say, I'm going to recuse myself, and I'm going to excuse myself, and you leave the room until that matter has been concluded, and then you go back in. I really recommend that strongly. I really think it's horrible, and I've just seen it happen a couple times when I was not actually the lawyer. I just happened to be at a meeting for other reasons. And I've seen it happen a couple times where the person will sit there after they've recused themselves, and you can just see there's emotion. You can see people make faces, they nod their head, they go like this. It's just not a good idea to do that. You're better off if you're going to recuse yourself because you know that there's some reason that you think you can't be fair. You should just walk out. They'll tell you what happened. Or you can watch it on the video. I mean, in a lot of towns, you can just go out into the hallway and watch it on a video monitor. So that you know when to come back in or they'll come get you. And then we talked about the executive session, the confidential information, and that is part of your code. It's 412. I mean, it's, I don't have the site there, but it's 16.1 and 16.2 are the two sections of the ethics code in Rocky Hill. And if you do disclose confidential executive session information, you are subject to a letter of warning, reprimand, or censure, and members of appointed boards or commissions are subject to removal or suspension pursuant to Charter Section C412. So there can be consequences if you disclose confidential information. And that's just with regard to this, without talking about other, like I talked about the attorney-client privilege, et cetera. There could be much more severe consequences if you disclosed information under those circumstances that I'm talking about right here. And then characters and traits. So your ethics code is promoting certain characters and traits that you should all exhibit, and I'm going to talk more about those. But honesty, integrity, fairness, respect, effort, and decorum, they're all listed in your code of ethics, and they're all the things that make an effective leader and allow you to do the work in a way that benefits the public interest. And, okay. Now we're going to talk about how to actually be an effective chair or member of a board or commission. And I just started off by just going over the town council rules of procedure at the very beginning. You've got the rules that follow the Freedom of Information Act. You got 3 kinds of meetings: regular, special, and emergency. 6 members are a quorum under your council rules. You need 5 affirmative votes to pass a measure or move a question. So that if you had a quorum, so under your rules, 6 are a quorum. And if you had a 4-2 vote, though, that's not going to be sufficient, even though you have a quorum under your rules, because you need 5, according to your council rules. In other commissions and boards, if there is no such rule, and you have a quorum, and you have a majority, that will be sufficient. Most commissions and boards do have set out voting requirements, like the Zoning Board of Appeals. You've got to get 4 votes. You got 5 members, you got to get 4 votes. If you don't get 4 votes, 3-2 doesn't win it. So unless there's specific requirements, if you have a quorum and you have a majority vote, that should be sufficient to pass. But most boards and commissions and the council all do have specific requirements. No, there's no, with regard to a quorum, there is no requirement that you have a certain number of members of a party. Minority representation just requires they have so many people that are seated, but there's no requirement unless there's a specific, rule or bylaw that you've adopted, but there's no requirement otherwise. Okay, I'm sorry. Okay, and then you have your rules of decorum, and I'm going to go over those. But with regard to the public hearings, you have 2 minutes to comment. So meetings are regular, special, and emergency meetings of the council. And then the council will have a public hearing where they're going to take testimony, evidence, et cetera, and hear from the public, hear from experts, et cetera. So those are conducted as public hearings, and you're going to have 2 minutes to comment as the general public, and there's no rebuttals until everybody speaks once. So if you have a certain position on an item, everybody who's in favor gets to talk once, and then if you want to rebut and you want to speak a second time, you have to wait until everybody's got a chance to go already. So if somebody wants to speak a second time, if you're the chair, you just ask, is there anybody else that's going to speak, on that position before we hear from him again or her again? That's the easiest way to handle that. And then it says if there's no specific rule, and then once again, and I don't, I'm going to say it, but there's no personal attacks. Okay, so when you're debating things, it's always on the merits. It's not a personal attack on somebody. That is just not anything that you ever need to do. And if there's no specific rule, you default to Robert's rules. And you really don't need to do that a lot in Rocky Hill because you do have a lot of rules and procedures, and you've got the statutory rules. I think that you may default to Robert's rules at times when you may not have the proper, you don't have sufficient rules to deal with unruly members. And with regard to discipline, there are, if you look at the 11th edition of Robert's Rules, it's a much more expansive version than the prior rules. And it gives boards, commissions, and any voluntary association, it gives you a lot more leeway to expel people who really engage in bad conduct. Like if somebody assaults somebody else, you may not have a specific rule that, you shouldn't have done that, but under Robert's rules, that type of conduct would be sufficient to have them expelled from whatever it is as a member. So if you had a situation where you didn't have it, you can always look at that. And I've had to unfortunately do that at times. Not for towns. I represent nonprofit associations that have big boards and they get into all kinds of trouble. I'm sorry. All right, now, to start, we expect everybody to be fair. Be fair and impartial. You're conducting the public's business. The public has to have confidence in what you're doing. My experience as the chairman of the ZBA for those years and as a member was that if we gave everybody a fair opportunity to address us and to speak, that they were generally satisfied with our results. Not always, but generally. If people think that they've had an opportunity to be heard and you fairly consider what they have to tell you, they will generally be satisfied with what you decide. If you don't do that, even the best of decisions are going to be not well received.
So where does the 2 minutes come in? Is that a hard and fast rule?
The 2 minutes is in your town council rules. So in a town council meeting, it's 2 minutes. It's not for boards or commissions. I mean, if you're in front of planning and zoning and you're going to do a presentation, you have people go way more than 2 minutes.
Sometimes it is 2 minutes at planning and zoning.
Well, if they've adopted that rule, then it's 2 minutes and everybody has the same amount of time. So generally, my experience in planning and zoning has been that, the public has a certain amount of time and then you have parties to it. So not only do you have, typically if you're actually going to really have opposition, you're not only going to have the public, you're going to have people that have intervened in that matter. You're going to have your abutters that have a right, and they're not going to be limited to 2 minutes. And you're going to have potentially environmental interveners, et cetera. So the parties that actually are part of the case or the contest are not going to be limited. That public comment, if they limit it to 2 minutes, is 2 minutes, and it's fair and it's uniform. So that is how it's going to work. And if you are a member of the public and you want more time and want to participate, try to file a motion, try to get into the case. Because what will happen is if you're a member of the public and you just participate and like in a zoning case and you don't think that the settlement is fair, the court's going to have a fairness hearing afterwards. But if you didn't intervene and you show up at that fairness hearing, the court's really not going to care what you have to say. That's the reality of it. So that's just the reality of how it works. Now, the public comment is incredibly important because you have elected officials and you have appointed members, and they have to be responsive to that. But from a legal point of view, that's why you have those kind of limits. Okay. As I said, the public has to have confidence in the basic fairness of the procedures, and the chair generally tries to stay out of the debate, but the chair votes. And typically what the chair does is, you address the questions in the debate through the chair, and what I find is the most effective thing if you're a chair and you really want to participate in the debate is that you wait for the motion to be called and you've got your first and second, and then when you have the debate, you would take and announce your position, and since you're the chair, you can wait until the very end. And that is what I would recommend if you're a chair on how you handle those things. And everybody else, they're going to go through you and they can go back and forth. But I would try to limit your involvement as much as you can. Because as the chair, you're kind of the referee too. So you want to try to be as fair as you can. Especially when this happened a lot in the ZBA. I'm the chair, I'm trying to be as fair as I can, and the people there, if you vote against them, they still don't think you're being fair. So you could try your best. It's all you can do. All right. Next. And this is something that drives people crazy. Punctuality, be on time. Gosh, people, I know you're all volunteers, and so you don't get paid, but you volunteered and you want to do this. And when the folks show up, the members of the public show up, and they have to wait because people aren't there, they really get a bad view of things. And it's really it's not fair to them. You have to have a quorum to transact business. So when we're on ZBA, if I only had 4 members, I had to tell them, I got a quorum, but you need all 4 votes. I don't have 5. So if you want to come back next month, you can pass and come back next month when we got 5. So you can, if you get 1 vote against you, you can still get it. Lots of people would go to the next month, but they've had to advertise, put the sign up. Lots of people don't like having that sign. Their neighbors are asking them tons of questions. And so it's really just not fair. If you volunteer, and I'm not trying to lecture you guys, I understand we all got our lives. And when you volunteer for stuff, I do a lot of nonprofit stuff. You just do the best you can, and I understand that. But you really should try to do the best you can when you volunteer for this stuff. Because when you don't do what you're supposed to do, it affects other people. And most volunteers appreciate short meetings, so I'll try to go faster. But, keep it on pace, keep it relevant. Know your current events. So if you have bylaws, if you've got regs, have them handy. So you can flip it open and say, here it is. It's horrible to have to be asking somebody, oh, we don't have that. How do we get that? And you embarrass your liaison or whoever your clerk is. And I have follow Robert's rules with no specific rule or procedure, which I've already talked about. And also consider the state statutes, like freedom of information and the charter and ordinances when you're going to rule on stuff. I mean, this is pretty much common sense. But to me, I'm always surprised, and I don't mean to criticize anybody, I really don't, okay? Because as I said, I know we're volunteers, but I'm always surprised if I go to a planning and zoning or a similar type of a hearing, and I've got commissioners that don't know their rules and regs. Now, I'm not saying you have to memorize them or you kind of know them verbatim. It's not a memory test, but you should have a general idea of what they say, and you should have a general idea of what's on that night. So when you come in, you can do business. If you don't do that, and if you really don't, then have the thing in front of you so you can at least flip open and try to read the thing while you're there. Because I know how it works, believe me, because I've been on boards and commissions myself. So, but I would say that that's really important, and your meeting will go so much faster too when you're ready. So you won't have to be looking for things. And this is all basic stuff. You know, you need to have an agenda. You know, make sure your agenda's good. It really specifies what you're going to talk about. You know, special meetings, you can't add them. Otherwise, you can by a 2/3 vote. And like I said, you know, keep the thing on track, avoid irrelevant discussion, you know, keep it moving. Tell people, look, you know, we don't really care what Aunt Sally made for Thanksgiving. You know, let's talk about what you're here for tonight. Because, you know, people tend to wander sometimes. And, you know, you can be really nice about it and just keep them on track. Yeah. And this is something that used to not be that important to say back in the old days, but I think it's more important nowadays. Stay cool. This is War and Peace, you know? I mean, you're to do the public business. Everybody has the public's best interest at heart, even though you might have different ways to get there. But everybody's acting in good faith. I mean, I got a pretty good feel for people in this town. I've been living in this area pretty much my whole life. And I think that, you know, there's no reason to really to lose your composure, to start calling people names or any of those stupid things that people do. If somebody gets out of hand and you're the chair, you just have to tell them to stop or get to leave. And when you are enforcing the rules, and this is what I was talking about before, when you're the chair, you got to be neutral in how you enforce the rules. So if somebody whose side you really are going to vote against is pushing something, you have to enforce the rules as neutrally as you can, even though inside you may want to tell this person to stop, you know? But you've got to give them a fair shot. And one of the things that I really think is when you have a hearing, well, it's probably required for planning and zoning. When you have a hearing, you know, the applicant goes first, then everybody else goes, but you should always give the applicant the last chance. That's always the fairest way, because they're the ones that have the burden of approving, and the court usually expects that. All right. I'm still going on this. All right. No personal attacks. The pending motion, no questioning motivations or personalities. Comments to the chair. Now, abstention. Now, abstention, this is actually an important principle. If you abstain, it still counts as a vote. All right? And so it counts toward the quorum. You shouldn't abstain if you should be recusing. You should abstain if there's something like you weren't at the meeting and you didn't listen to the tape, so you shouldn't be voting. So, but you're still there, and so it's still the quorum. Whereas if you recuse, you're not there, and you're not going to get the, it's not going to count toward the quorum. But if you need to recuse, that's what you should do. You should not abstain if you should be recusing because you have a conflict. Okay? Abstention is because there's some reason you can't participate, but not because you have an interest. If you have an interest, that's recusal. And I think I just went over that. I go over it right here, recusal, yeah. A conflict, you can't participate, you can't discuss. The safest practice is to leave the room. And now let's talk about site visits, which is always an incredibly controversial topic. If you have a site visit and you have a quorum of your commission, it's a public meeting. You need an agenda, and you need to have minutes that reflect what transpired. And there should not be discussion or deliberations. If you're gathering evidence, you're allowed to do that, but that's it. This is part of the public record. And so when you go for an inspection and you're taking evidence that you're going to use to decide a matter, it is not fair if other participants to that matter do not have equal access to that information. And freedom of information recognizes that, and site visits are extremely tricky, and they can cause a lot of problems, and I would always recommend contacting us or whoever your town attorneys are before you do it, so that you do it properly and you protect the record, and that you're fair to everybody. Because there's a lot, I mean, one of the things, I was on ZBA, I remember one of our members wanted us to give him an ID card so he could go to people's houses and identify himself and like walk the property by himself. It was like, no, you can't do that. You know, you're not going to get ID cards, you're a member of the Zoning Board of Appeals. It's like, you're really not supposed to do that. And then you're taking evidence. People don't have an opportunity to, you know, ask you a question as maybe you didn't look at it right, you know? And that's why those rules are like that, to make sure that it's fair. I mean, it's okay to drive by. It's okay to stop. It's okay to, any member from the public can do that. So any member of the public could do what you're doing. But if you go onto the property and you start asking the owner questions and getting a tour yourself, and then you go back and use that information to make a decision, that is completely not fair and it's inappropriate. And if it's found out, it'll be a basis for an appeal and a reversal. But I mean, I used to drive by people's houses all the time when I was on ZBA, you know, because you're on the street, you can do that, you know, just because you want to get the feel, you know, of you know, what they're trying to do. But you always want to look at the neighborhood too, see how it fits. And now I have do your business in public. So everything that's being used in the hearing should be part of the record. If staff gets emails, they should be marked and put in the record. If there's a discussion, and I was chairman of the ZBA, you know, you get these calls from people and you need to disclose that. You need to put that on the record when you go to the hearing. You need to tell them, you can't talk to me, you can't do this. That's what you're supposed to do. And I had a very contentious hearing, the one that had the state police, where one of the commissioners had publicly stated his position at some social function. And the applicant brought in a witness that testified to that, and the guy had to recuse himself, which caused a mini riot, actually. But the point is that if you're going to vote on something, you can't take a public position, all right? And there's a reason for that, and there's a lot of reasons for it, and it's what the rule is, but one of the real reasons is, and it kind of makes sense if you think about it. If you're on a board or commission and you hear part of a case, all right, you're gonna have 3 days of hearings, you hear 2 days of it, okay? And then you say in public what your view is, okay? You've said it, somebody heard it, okay? And then on the third day, you hear something that might have changed your mind. But once you say it, it's really hard to change your mind. You should wait until you hear the whole thing and then decide. Because once you say it, it's hard to change your mind. You're not supposed to do that. That's why. So if you want to know why do we do this, it's not just some rule, there's a reason for it. So if you want to make fair decisions, that's how you do it. And as I said, disclose everything's on the record. And alternates, you know, alternates should be there, pay attention and everything, is if you got to vote, then you need to participate. But if you are excused at the end of it, then you're done and you cannot influence it. You should not take part in the deliberations, you should not take part in the discussions, and you should not be providing information that is going to be used in making the decision. And I'm going to say another thing about this, and this is something that happened in a zoning appeal I handled in another town, that you had commissioners in a very contested matter that was a lot of money involved with a commercial case, commercial development, and you had the commissioners on the very last day after a lot of hearings, when they were going to vote, testify. Had a commissioner come up and say, I went down there, I looked at the traffic counts and the whole bit. And then they voted like it was part of the discussion. That was not. That was evidence that commissioner gave that applicant never got a chance to rebut. And then they just voted. And you know what? The court reversed back. So that's another thing to avoid, okay? And if you do it, and the applicant, and really you got to be careful, because if you do it and the applicant doesn't ask, you still should ask them if they want to rebut that, if the chair realizes this happened. Because in our case, the applicant didn't ask. We really tried to use that as a reason as to why, you know, and this was after the fact when we got it, you know, but the court did not accept that. And so, you know, that appeal, and we spent a lot of money on that appeal. It was horrible. But I had advised, I told him from the beginning that was going to be a problem. So the other lawyer was a good lawyer, Dave Sherwood. He knows what he's doing. So beware of that. Voting. Okay, yeah, so as I already went through this. Like I said, the ZBA is 4 out of 5. Unless otherwise specified under Robert's rules, a quorum is a majority of the members. And when people ask me that, what I tell them is, like, if you've got 5, so it's basically half plus 1. So you round it up, okay? So that's basically how you do it. under Robert's rules, but most of your boards and commissions have that spelled out what a quorum is. And then like TPC has particular requirements, like on a zone change, a majority can approve that. Other matters require 2/3 vote. And so the point is just be aware of what kind of vote that you need. And once again, if you do miss a meeting and you want to vote, and I've done this, you go and you listen to the tape, you look at the exhibits, and then when you're going to deliberate and vote, you put on the record that you listened to the tape, you looked at the exhibits, and you put it on the record, and then you can vote. If you don't do all that, even if you listen to the tape and looked at the exhibits, you need to put it on the record, because if you don't, then it's like it didn't happen. All right.
The member said I looked at it, but they never came to the town to look at the exhibits.
Hold on one second. I just want to make sure the people who are listening at home.
Okay, so I'm
Capture
not
what
going to
you're
answer
saying.
this question. I can already tell you, because you're going to ask me a specific question about something, and I'm not going to answer it. But I will tell you that if there are exhibits, the member is supposed to look at them, and if they didn't, they shouldn't vote. Because they're going to have to represent that they did that. So if they represent that and they didn't do it, they'd be misrepresenting. And I know I don't mean to be like, doing this, but I would think that's pretty common sense, right? I mean, all right, ethics. Well, we already went through this, and I just wanted to go through. You always think that, always tell the truth, and as best that you can. I mean, sometimes I hate when people accuse somebody of not telling the truth because the person told what they thought was the truth and ended up not being right. If you do your best and you tell what you really think is the truth, and that's the truth as far as you know, and then if you're wrong, you can change it. But I hate when people accuse other people of not telling the truth when they made a good faith effort and try to say that they're lying. When I say fairness, as I said, divide the time reasonably amongst the speakers, but always give the applicant the last opportunity. Attend meetings, be prepared, and don't disclose confidential information. Now I've got just a few quick on the conflicts of interest. You really should not have any financial interest in any contract with the town if you're a council member, or if you're a board and commission member, anything that has to do with your board or commission. Should not disclose confidential information for your financial or personal gain or anybody else. You really should not, and this is not under your ethics code, but under state law. You can't solicit or accept any gift having a substantial value from anybody who wants to do business with the town. And once again, your ethics code requires a written disclosure for personal gain. And we always advise erring on the side of caution. The only thing is that the state ethics office does not have jurisdiction over municipalities. So that's why you have your local ethics ordinance yourselves. That's what you need to have. Now, liability. So this is something that I do like to talk about. It makes people uncomfortable, but when you serve on boards and commissions, there's always a potential for somebody to sue you because they don't like a decision that you made. And the state has what we call sovereign immunity, which means you can't sue the king. And it's pretty absolute unless it's been specifically waived. But it's a very strong defense. Municipal employees have something called governmental immunity, which is not as strong, but it does cover virtually any situation where you're using discretion or making good faith action. The only time that you're not going to be, you're not going to qualify for that is if you do reckless, wanton, criminal type, intentional things. And there's a state statute, 7-101A, that says that if you do get sued, that the town has to provide you a defense. And they have to pay for everything unless at the end of the day, the court finds that you acted in a wanton and malicious manner, in which case the town can ask to be reimbursed, which has happened. Unfortunately, not in this town, but it has happened. The flip side of that is that it's also happened where you've had an employee who's asked for that, and the town has said no because you were bad. And when the case is over, it was found that they weren't bad, and then the town has to pay for all their legal bills, which it gets dicey because the individuals usually hire way more expensive lawyers than the town would have. So the bills really run when that happens. It doesn't usually happen though. And I don't think I'm not familiar with it ever happening in this town, at least not through my own experience. And the last thing is just on referendums. Referendums can be tricky, for education, for the school, et cetera. And so you can't use public money to publicize a referenda. That is going to get you into trouble. But you can have explanatory text. Those are usually prepared by the town attorneys or the Board of Ed lawyers. But usually it's the town attorneys, because usually the towns are the one that are actually financing and buying the stuff. The Board of Ed is not. So when you're building new schools, it's usually the town. It's not. And usually the town attorneys do have lower rates than the Board of Ed lawyers. I can guarantee you that. But explanatory tests, and like you can do stuff like, when they have the kids take the things back in the backpack and stuff like that, as a way to distribute it. Some of those things are allowed. But whenever you're going to do those things, you should really check with your town attorneys, because those are really strict rules. And the referendums usually cost a lot of money, and there's a lot of time to get it on the ballot. So if you have a mistake, it's going to be really bad. But we find that these are really things that are really carefully gone over. And I'm just telling you so you have a general idea. All right, so in conclusion, and I'm sure everybody's happy to hear that, and this is true, municipal government is where the action is. We're in the front line, we're in the trenches. Compared to the Congress and the state legislature, we move a lot faster. When you have local issues, you got to respond to them, because you're going to see your neighbors in the supermarket. So you got to deal with them, And we're here to help you guys. I mean, that's what we tell you. We're here to help you. We have a lot of lawyers. I see Rich Roberts, one of my partners, sitting back there. And Rich has got many years of experience as a municipal attorney. I do too. We have a lot of other partners and younger lawyers that do. And we're always available anytime. And it's always better to call us, because prevention is way cheaper than a cure. Trust me on that one. And the last thing is, and this is the moral of the tale of that FOI thing with the police chief. If you make a mistake, think reconsideration and ratification. What they should have done in that case was they should have called a regular meeting, noticed it properly after they screwed up on the emergency meeting, and fired him. Would have paid him another month of salary as opposed to 2 years by the time they got to the Supreme Court. And most of the time, if you make a mistake with decisions, you can always ratify them by having them reintroduced. And that's another time when Robert's Rules comes in. That may be one of the rare times when you're really going to look at Robert's Rules, because particular motions can't be brought the next meeting, they got to go to the meeting after. And so if you have somebody who is a procedural, person, and they're going to want to say, well, can you do this at the next meeting? If you screwed up the last meeting, or I shouldn't use that terminology, I'm sorry. If you didn't follow proper procedures at the last meeting, you can't bring it up to the next, you got to go to the one after. Because Robert's Rules does have those kinds of limitations in it for certain types of motions. And so that's someplace where it could come back, and you'd have to be familiar with them. But my advice always is, if you think you've made a mistake, don't be stubborn, admit it, fix it. Because that's going to save you money at the end of the day. And that's basically all I have. I mean, the next thing I'm going to put up here is going to be questions. If anybody else has any questions to wrap up. And I'm almost an hour early from the agenda, which I'm happy to see. Oh, hold on. Dana's going to bring the mic over so we can
The folks
pick it up.
at home can hear you.
If you have a quorum in a meeting and then somebody has to recuse themselves, that brings you below the quorum.
It does.
So you can't have a vote? Can they go abstain? Okay.
I mean, if there's a reason for them to abstain, then they can abstain. But there has to be a reason. That is the rule. If you have a conflict, you should recuse. That's the rule. If you have a reason to abstain because you haven't listened to the tape or some other reason that is not a conflict, then you can abstain and you still have the quorum. And I understand the temptation to do all these things. And so I'm talking to you, it's like this, okay? I make a little joke here. I always say this with my other lawyers, we always talk about this. A lot of the things that we do, when we do them, if they ever made the front page of the Current, the public would be like, wow, really? So, when you do these things, it's up to you. And my advice legally is you recuse if you have a conflict of interest, you abstain if there's some procedural reason, that's what you're supposed to do. And it's up to you to decide that. I mean, on recusal, I'll tell you one last thing. I mean, I had this in Rocky Hill a long time ago. And on recusal, that is one tough issue to force somebody to recuse on conflicts of interest. It really is. To say somebody, if somebody says, I know I can still be fair about this, there's very few circumstances where I'm going to tell them, no, you can't, you got to recuse. Almost none. I mean, there's some, but almost none. Because it really is up to the individual. It's very difficult on recusals. Unless you got something like, obviously if somebody is in a butter, they can't vote on the thing, that's by the law, but it's a much grayer area most of the time. You have to really rely on people to do the right thing. Anything else? Yes.
Board member is using their personal cell phone, say texting during a public hearing. Is that cell phone subject to FOI?
Oh, gosh, I hate that question. Boy. So I had this happen in a council meeting in another town. And so the council member got a text because her son had to go to the hospital. Another member wanted to see it. She wouldn't let him. It ended up being a real fight. And so, you got to use some discretion. If you want to be technical, you want to push it. Yeah, we get to look at the text. But you could get embarrassed. I mean, if somebody tells you, it's personal, you should respect that and not go further, in my opinion. Anything else? Unless you want to have a mom tell you, believe me, it wasn't pleasant for the other members when she did that. Anything else? Thank you very much for your attention. I hope it was helpful. And I appreciate it. Appreciate the time. Thank you, Dana. And I'm not charging you guys for this.
Thanks for your time, folks. Have a good evening.